Well, good afternoon, everybody. My name is Todd Albert. For those of you just joining us, I am the Public Records Advocate and Chair of the Public Records Advisory Council Non-Legislative Subcommittee. And today's meeting is going to be focused on hearing or receiving testimony from three different public bodies about how they handle what they define as personally identifiable information when it comes to receiving, processing, and disseminating personally identifiable information. Although we do not have a quorum to vote on the agenda, how it will proceed today is that we will hear from our guests. I will mention I've been away from the office for about a week, came home in the wee hours of the morning, and I'm operating on just a few hours sleep. So I think I will leave lengthy introductions to the guests to introduce themselves. But we are hearing from a diverse group of public bodies today from the state and local level, and I really appreciate their time and energy in being here today, and I'm looking forward to the information they could provide that I think will help this subcommittee and the PRAC as a whole generate useful advice and guidance to public bodies about how they process public records requests. After we hear from representatives of the Portland Police Bureau, the Oregon Department of Environmental Quality, and the Oregon Health and Science University, we will open the floor up to public comment on the issues that were raised in today's meeting. And then if additional members join us, we will conclude today's subcommittee meeting by attempting to schedule subsequent meetings and testimony. So just because this is the first time this subcommittee has heard testimony, I just want to put sort of our process on the record, which is each guest is invited to speak for 5 to 30 minutes about the issues that we have invited them here today to testify about. It's possible you will receive questions from the subcommittee during your testimony as well as at the end. There will be no questions to the witnesses or those testifying from the public. And then we'll move on to our next speaker. And if any of those speaking today wish to provide any written materials, please submit them to me directly and I will post them as part of today's testimony. And then just finally, I want to comment on something that came up at a recent legislative subcommittee meeting. And this is without any judgment of the speakers, council members, or members of the public who participated in that meeting. But I just wanted to remind everyone that we are all here to discuss issues that are great importance to members of the public and public employees as well. And I hope that we can all remain respectful in the language that we use. And that although I know these issues often involve a lot of emotions for people on both sides, I, as the public records advocate and chair of this subcommittee, firmly believe that Oregon's public records law is intended to be a law of disclosure and not confidentiality. And although we may sometimes view some requesters as difficult, I don't think it's fair for any of us to judge those requesters or the circumstances from which they come or the reasons that they're asking for records. Again, although I have no reason to be worried about any of our speakers or committee members here today, I just wanted to state for the record, I want us all to remain courteous, civil, and cognizant of others around us and the fact that they come to these issues from all backgrounds and levels of authority and knowledge. So thank you for that opportunity to say all that. And why don't we welcome our first guest, Tammy Weiss from the Portland Police Bureau. And I'll note that actually, Jennifer, I'm sorry, I don't know your exact title, but Jennifer Johnston from the City Attorney's Office, who I'm sure is a senior city attorney, deputy city attorney at this point, is here with us as well. And she may also have something to say, and we welcome her testimony as well. So I'll leave it there, and please take it away.
Can y'all see the slides? Okay, and Tammy, you can see them too?
Yes, I am ready.
Okay. So the city of Portland gets over 33,000 public records requests a year. A majority of them go to the police bureau. And so Tammy, as the acting records manager, oversees those. And I, as the senior deputy city attorney, oversee our public records program and provide specific advice on legal issues and procedural issues arising out of all of those requests. So Tammy, if you want to proceed and if you want to tell the specific number of requests, I was thinking it was around 24,000, but I know it fluctuates how many PPB gets.
It has remained around 24,000 the last few years. It does increase a little bit each year. The last 5 years have steadily increased. However, we have actually taken on some of the releases to outside agencies, governmental and law enforcement agencies, and there are some requirements for release on those type of reports also. And you'll see in the slides some of the examples. So I won't read everything on the slides that we prepared for you, just so you can have a little bit of an overview of what we really do. This slide just talks about how we, the Police Bureau and the city, strive to be transparent as much as possible. I don't have in this slide, but we have started posting a lot of information, which makes it more transparent for anyone to be able to view those without even having to make requests. I know the city has done a lot more postings than actually the Police Bureau has. I'm trying to get more postings on there for that. But that comes up with the PII information that does need to be redacted. So there are certain cases that...
Hey, Tammy.
Yes.
Sorry, I hate to interrupt, but I would love to hear a little
Okay.
more about what you know, or Jennifer, of the city's efforts to post more information proactively, and specifically what kind of information PPB is capable of or is looking to post ahead of time, even without requests.
So what PPB has been posting is mainly the hot topics. So previously it was kind of a rule of thumb for us, was if there were requests, multiple public records requests for the same incident, we would post that. It ended up being that a majority of the protest cases or any related documents on the protest were provided. They were all posted. That's been the main ones that the Police Bureau has done. Anything high profile, some of the cases I won't mention by name, but were pretty high profile. Those type of cases and even photographs and those kind of things were also posted. And I can't speak for the city. That would be Jennifer.
I thought you also posted officer involved shootings once there was a grand jury. I believe you also, as part of our open data initiative, are have several open data sites for the Police Bureau that are, I don't know if I want to say manipulable, if that's the right word, but people can put in.
It's interactive. Yes.
Thank you.
So our strategic service analysts have put together a tremendous dashboard that people can pretty much take out any statistical information that they are trying to get themselves at no charge, since it's already in there.
Right.
And I don't deal with a lot of that, so I don't post those. Those are done by SSD, but yes, we do the officer involved. We try to release that at the same time as the district attorney releases the transcripts on those.
Similarly, citywide, there's several different open data initiatives where for example, we get questions about the EEO makeup of city employees, so there's a dashboard for that. So there's several different dashboards that the city has worked on. as for proactive posting, to some extent, it's similar to what Tammy was saying. When there's something that seems to be high profile, or there's a lot of interest, that is posted on what we call our proactive pages associated with the public records portal. We also encourage other bureaus, they all have, web pages, and so they post more of their project information. There were several initiatives that were sort of getting started to identify and post additional information prior to COVID. Those took the back seat to sort of, I don't know what word is most appropriate, getting by, survival, getting through COVID. And so now, as I'm hoping on the other side of that, we're re-identifying, and so starting up in a small way. So for example, reporters often ask for our tort claims notices. So beginning this year, January 1 of 2022, those are being posted in a searchable format for requesters. And we have a roadmap of other records that we routinely get requests for, and we're working through methods of just posting those so they can be searched. We also have a robust e-file system. So like all of our council documents are searchable and posted. So anything that goes before council has long been searchable and posted, and a lot of other documents are searchable and posted. Our archives is open to the public, so people can go there and access records that are a certain age. So all of those things are things that the city has been working on and continues to work on to make more records proactively available for free.
Does that answer your question, Todd?
Absolutely. Thank you.
Okay. This slide just mainly talks about the types of requests that we cannot release. It doesn't necessarily mean that we're not going to release them or that there is not a way to release them. We always advise our requesters how they can go about getting copies of the reports, such as if it's open with the district attorney's office, they just need to contact the district attorney. If it's a DHS case, we have a website. They actually use an online service also. We give them that information so that they can make the request through them, so they can get copies of those reports if they are available to be released by the appropriate agency.
I would just note that some of these types of records that can't be released sometimes make it difficult to attempt to automate the system, because a person has to check on certain of these statuses, and sometimes Tammy's record specialists have to read certain parts and review certain things to determine what can be released or not.
So this slide is required document or required information that needs to be redacted. So criminal justice information, anything that, any of the information that we get, personal identifying information that we receive from our law enforcement data system or criminal justice information system, those are redacted, which normally is and I just put Oregon driver's license. It's actually any driver's license, social security number, FBI number, a state identifying number. Those not only are required because of it's a requirement through LEDs or NCIC, it is also to protect citizens from identity theft, which has been a huge problem. So that information is automatically redacted on some of our requests. On portions of our reports, they are automatically redacted. So they will see where a driver's license should be, and it would say redacted. We have how we print out our electronic copies of reports on those style sheets that we send out. They will automatically say redacted in those boxes.
I have a question, Tammy.
Mm-hmm.
And I know I said you might get interrupted with questions during this presentation. I should have really said I will be interrupting you with questions during this presentation.
Right.
But I really want to learn more about what you're saying. So Jennifer, you had mentioned it's difficult to automate these systems because of some of these redactions that have to occur, but you also do have these set categories, at least for some of your records, that need to be redacted. And so how is that handled? Is anything ever like sort of redacted at the time it's put into the system, or has the ability to be redacted by the system based on set categories before you produce it?
Well, that is what she was just describing. So their region system has style sheets that they can arrange. And when they put, say, Oregon driver's license in the category place in region, the style sheet will automatically redact that when they print it for public records. However, if an officer is talking to a witness or somebody, and the officer is given a driver's license and puts that in the narrative, or if it's an identity theft case or a fraud case and as part of the narrative, they're given PII, then the style sheet can't automate that redaction. Now we have looked in some other software, and that searches for number sequencing that might be able to do that. But since in a lot of these, and Tammy will talk more about this, they have to review for like medical information and other things, their record specialists end up needing to read the narrative every time, because officers are given a lot of the public's personal information in a lot of different ways. It was somewhat surprising to me. The reason they're so careful with CJIS is if they mess this up, CJIS will not, if you have a certain number of infractions, you lose your CJIS access. They made me get CJIS certified to be able to look at the records, to advise them on CJIS to make sure we're in compliance. Which if you want to do that, it was a good time.
Our system doesn't recognize the number. It just recognizes that there was something in that field. So whatever was in that field, it will be redacted.
I see. Thank you. And I just want to acknowledge that subcommittee member Shasta Kearns-Moore has joined us. Shasta, I'm glad you were able to overcome the technical difficulties you were experiencing, and welcome to the meeting. So, Tammy, you're welcome. Please continue, Tammy.
Okay. This slide lists some of the information that we do release on victims, or actually anyone listed on a police report, unless it is a confidential report and there are other reasons that we would need to redact for usually safety concerns, like if the person is a domestic violence victim or a sex abuse victim, that kind of information, we do try to redact on those. But normally, per our DA, the things listed here are information that we do release. When we do post this kind of information, there are some unhappy citizens with their information out there for everyone to see. However, we are required to release that information. So
we have received calls from the public about why are we releasing this kind of information and that we are putting victims in jeopardy. But our DA has ordered that this must be released. So when we're, trying to balance transparency with protection, when you were releasing this kind of information to an individual who had a piece of paper at home, it does seem very different than releasing it to people who can publish it widely on the internet. And that does seem to be more of a concern now to the public. Again, we tell them that we need to comply with the law, which is why we have to release it. But it is something that we're seeing increasing concern about, and we're seeing increasing requests about safety issues, people being stalked, people being threatened, all of that kind of stuff. And I think that we need to figure out a way to be absolutely transparent about the public's business, but we need to figure out a way to protect our vulnerable victims. And I don't know that I have suggestions on that, but I hope that this committee can try and think of ways to protect like vulnerable child victims.
And we do have that on another slide. The biggest concern that the Police Bureau investigators have is there are a lot of victims, even though they sign a confidentiality form, that doesn't necessarily mean that their name or information can totally be kept confidential. So they will not come forward as victims. So that is a huge concern for our investigators. So we do what we can on those kind of cases, but it has been determined that that kind of information should be released. So here's some other mandatory redactions that we do for officer safety. Officer photographs are redacted. Undercover officer names and information are redacted. Usually these are reoccurring missions that they do, like prostitution missions, stolen vehicle missions. They actually do race car missions, so they don't want to have their photograph out there and have their cover be blown on that they are doing a mission at that time. So location is a big thing on that when they have reoccurring missions. Do you have anything on that, Jennifer?
No.
Okay. This is some of the information that we look for when we are reviewing reports, photos, videos, any type of information that has been requested. And there is the exemption for deceased persons, which may invade the privacy of the family of the deceased. That has been a big one for a lot of families. As we know, there's been a lot of homicides in Portland. Families are concerned about what exactly will be released to the public on their loved one's case. So the same is for specific medical or mental information. We redact that kind of information. Usually that is when they are taken to a facility or they're getting some type of medical or mental assistance. The financial information, of course, is to protect people from identity theft. A lot of fraud cases have copies of credit cards, copies of checks, all that. Those routing numbers, account numbers are all redacted. This slide kind of talks about the difficult part of our job, which, like I explained before, if the information isn't in those specific fields, it will not automatically be redacted. So we will need to read the reports and review them and balance the privacy information. So the narratives are always fully reviewed. Emails are the same. When people make requests for emails, I don't think people realize how many emails or text messages people really send. So we do ask people to narrow their requests down. There's significant information in those emails. People tend to talk a little more freely in emails. So all the emails that we pull from the system, they all need to be reviewed for personal information. Videos are the same. Videos take a lot of time, even with the best software that you can get. They can do some automatic redactions, but they still need to be gone through frame by frame, no matter how long the report or the video is. That's how we do our redactions. So, which is very difficult if you have a lot of officers out on a scene redacting all that. Do you have anything more on that, Jennifer?
No, I mean, the process is, of course, similar citywide. Emails have to be at least glanced at. Even if they're coming from the public, sometimes the public sends its representatives very personal information that we do redact before releasing it for the public. If they send medical or financial information.
Tammy, I have a question.
Okay.
You mentioned reaching out to requesters to narrow their requests. I'm just curious, is that generally through GovQA, and sort of what is your process or method of trying to work with that requester? Do you help them understand the types of records you have, or maybe even types like names of reports? Or I'm just curious as to your process.
Well, it depends on what they are asking for. So if they are asking for all emails with the word police in them, obviously they're going to get thousands and thousands of emails. So we will either call the requester or send them an email through GovQA asking them what specifically they're looking for. So we'll say they're actually looking for information on taser use. Well, that's way more specific, and we can get them a much better result for a lot less cost and staff time.
One of the things we did when we set up our request portal is PPB has a request type that's slightly different than the rest of the city because they get 24,000 requests a year. It was worth investing in them. And it lists the most common types of documents that people ask for. Like, do you want a police report? Do you want a name check? Do you want video? Do you want photos? And then there's another category, do you want other research? And so, if they want personnel files or if they want emails, they can get it. But before we had GovQA and we had the paper request, when it was a generic paper request, people often did not know what to call the name check. They might know the police report, but they didn't know what the thing was they wanted. And so PPB, even with the paper form, had switched to giving them a list of some of the most common types of records. And so when we went to the electronic request type, we did that as well. We also, City Council is now paying for someone to do email searches for public records so that we can do test searches. So, for example, I was working with a city requester, and one of the terms they had asked for was relay. And when we did the search, it came up with a huge number. And at first I couldn't figure out why. And so I searched my own email box. Well, at the bottom of every signature block in the city, it talks about how to get relay services for people with hearing difficulties. So they were getting every single email in this time range. And so, if we hadn't done the estimate, I don't think I would have realized, it just didn't hit me that we used relay all the time. And so we went back to the requester and I'm like, we're getting 17,000 emails and I think they're because of this phrase. And I don't really think that's what you're looking for. And the requester was like, no, I do not want that. And so, we worked on some other terms and did it again. And I think got down to like 250, which seemed about right for the topic they were looking for. And so, that's what we're able to do because the process evolved. We can do these test searches. We can, do iterations and narrow down and ask for terms now. We do get people asking for the word police and we try and explain to them. And like we had people asking for chief and, we're like, that is in every signature block of every single police chief and it will get every single one of their emails. Is that really what you're looking for? And usually that is not what they intended. And so when we explain like that, we can brainstorm some other terms. Not always, but usually. So
Thanks.
Anything else about?
This next slide is with the short staff that Public Records has taken on doing government requests and other law enforcement requests also, which is about another 18 to 20,000 more requests a year. Some of these requests, information cannot be released even to them because of some state or federal laws that we have. So one of them is adult protective services. We can release to other government or law enforcement agencies, but certain information needs to be redacted out of those because those are confidential reports. So like on those, the reporting party gets redacted for another government agency. So.
Yeah, and the other one, we now have to ask all public records requesters if they plan to use the request for enforcing federal immigration law, since state law requires certain information be redacted if that's the purpose.
Which a lot of people are very confused on that because we get a lot of requests for people wanting a name check for immigration purposes. So, they're trying to come into the country or they're trying to go out of the country. So they need what they call an immigration check. So they mark immigration because they think that that's what it is. We know that that's not what it is. So we usually confirm with the requester that this is what you really want and you really shouldn't have marked the one. We'll change the one for you. So, but that is a question that we do have to ask. So,
and this just indicates that the rest of the city, faces similar issues. We have, different redaction lists depending on the group. Our group that deals with cannabis applications, when they passed all of those laws, has, there's a whole host of things they have to redact around cannabis security and all of these things for people who are growing or selling cannabis and have license. So they have all these extra securities. With our revenue and finance people who deal with people's private information or finance information, again, they have a different set of redactions if people ask them information. We recently learned about not providing information about unclaimed property. Don't know if you're all familiar with that exemption, but we learned about that recently. Unclaimed property is exempt until you provide that information to the Division of State Lands, and then they publish that information, and that's to prevent those organizations who go around trying to find out what unclaimed property is and then contacting you and saying, you know, I know who owes you $500. If you'll just pay me 10%, I'll help you get it. In Oregon, we want you to get your property without charges. So all public bodies send the money to Division of State Lands, and you can, if you haven't done this, you should. You can go search your name on Division of State Lands. So anyhow, there's special exemptions there that we had to work through with the Treasury. There's just every bureau has different private information and different exemptions. And so just lots of documents have to be reviewed. And lots of times when we release information that we think is required to be publicly available under the law, the public is upset about that. They are particularly upset about the release of their dates of birth and their home addresses. People have raised numerous safety and concerns about identity theft about those pieces of information. I think that is all I have, unless there are additional questions. We are happy to answer. You know, I'm proud of the work that all of our responders do, getting out 33,000 requests. So we love talking about it.
Mhm.
Well, thank you both. That was very informative. I will just ask you at your convenience to please provide me a copy of the slides, and I'll get them posted with today's testimony. And Shasta, I believe you had your hand up first. Please go ahead.
Hi, thank you so much for your presentation. I'm sorry that I wasn't able to get into the meeting for the first part of it. So some of these questions you might have already answered. So apologize for that. You said there's 33,000 requests a year. Do you have any sense how many of your requests are from the media, researchers, organizations versus individuals who need them for their own private purposes?
So of the 33,000, 24,000 go to PPB. Of those, I thought about 17 to 18 were from a company called either LexisNexis or Metro, who are asking on behalf of insurance companies so that individuals like with stolen cars, things like that, can get paid. So, you know, those are generally termed as commercial requesters, but I try and remind people that, you know, members of the public are impacted by those police reports because people are trying to get their insurance payments. As for media, you know, I have not broken out the number of media requests.
We might have it separated out in our portal.
For PPB.
So they need to, when they make a request, they mark if they are, and we do this also because victims, we give free copies of reports to. So they can mark that they're a victim, or they can mark that they're public, or if they're media. So it is separated out that way. So we could pull the information. I should say Jennifer can pull the information.
I'd be really interested to hear, you know, what that is. You know,
Yeah.
I don't know if there's a public interest test,
You know,
through the system, but
it's really not the amount of requests that the media makes.
Mm-hmm.
It's the technical requests that they make.
Mm-hmm.
They don't usually just ask for a police report. I mean, I'm speaking for the police bureau, so
Mm-hmm.
they don't normally just ask for, you know, a copy of a police report. They ask for a lot of statistics or other type of training information, personnel records, those kind of things. They do ask for copies of reports. Usually those are high profile open cases. And of course they want everything with it. So, you know, you got to look at the videos, you got to look at the photos, you got to look at the in-car videos. So they're usually more time consuming than our regular requests. But there is usually a significant amount.
You said something about if there's a public interest. So, I mean, for fee waivers, we do look at, you know, waiving fees for public interest. It's interesting. I was just looking at like one media requester, and I think they had done 80 requests, and I don't think they had been charged very much because most of their requests were like pretty focused. Whereas there's a lot of other requesters who, you know, I'm working on one now that's like all the emails for 2 years that use certain terms. And so, you know, several different bureaus are spending, you know, 8 to 20 hours looking at emails for attorney-client privilege and other stuff. And so, you know, those requests are not comparable, and the amount of fees we could waive in those requests are not comparable. The city also, even though not required, does economic fee waivers. As Tammy was saying, we waive the fees for crime victims who are asking for their own police reports, but fire, BDS, and BOAC also do economic fee waivers because sometimes people need those records for a whole host of reasons and can't, you know, afford even the $10 fee that some of those bureaus charge. And so we try and have a system in place where they can say this would cause an economic hardship. I'm on a fixed income. Okay, we'll waive your $10. The public interest, you know, is kind of a different test, the one under the law, where people say, I'm going to widely disseminate that. Most members of the public can't meet that standard, you know, where they're going to be sharing it widely. So that's why we have a slightly different test to meet what we saw as a public need. I can try and get the number of media requests, and I can either send that to Todd, or I think we're testifying on the 26th. I don't know if you're part of that. I'm sorry, the 22nd. I could bring that information.
Is that to this body?
It's
no,
a
it's to the
different
legislative.
subcommittee.
Yeah, it's
Got
a
it.
legislative subcommittee. Jennifer, you could send those numbers to me and I could disseminate them to the subcommittee.
Okay. I
Thank
may
you.
not have them all ready much before the 22nd. I don't know if you have shorter timelines.
No, we're taking our time to develop
Okay.
our work, so
Okay.
please get them to me when you can, and
Yeah.
I'll provide them to the subcommittee.
Okay. Yes, I can do that.
I will say a lot of the fee waivers, the economic fee waivers that we get, we take upon ourselves, because a citizen will make a request and they will mark that they're the victim because they truly feel that they are the victim, but they're not listed on the report as a victim. Like if you're involved in a traffic crash and you're hit by a drunk driver, you feel like a victim. Those are not marked as a victim. That's under federal coding. They are marked as a traffic driver. So on those, we do make a lot of exceptions on those where we do the financial fee waivers for those where they truly believe that they are the victim.
Interesting. Thank you.
Any other kinds of numbers you were looking for, Shasta, if I'm going to be trying to pull them, besides like the number of media?
Yeah, I mean, media, but also researchers or nonprofit organizations, just anybody who's kind of, you know, requesting things that isn't about their own personal life.
Yeah, and I don't think I would be able to pull researchers because we don't categorize them like that.
Interesting.
So,
Okay.
I mean, I just want to be honest, they would just go into a general public pile.
Okay.
Not
What about-
non-victim public.
Another thing I'm curious about is how many like data requests, like data level requests rather than specific records do you get? It sounds like LexisNexis is probably that, but
LexisNexis, they aren't data requests. They're asking for police reports to provide to insurance companies so that people can get their insurance claims filled. The data requests we get, I would say, are more typically from the media. You know, there's one right now where somebody asked for 10 years of a particular kind of homicide, and we're trying to figure out if we've been tracking the data by that subcategory. And so sometimes we have the data and sometimes we don't. I don't know if you were on the call when we talked about our open data portal. You know, PPB does have an interactive data portal. And so one of the reasons they do is so that people can, you know, engage in some of that research at no charge. And the city has an open data project where they're trying to create more portals with different kinds of data and make that information proactively available to the public so they can get that information without making requests. And I thought Adam also had a question.
He does, but I'm going to jump ahead of you for a second, Adam, because I just want to follow up on Shasta's question. Jennifer, if I was interested in, because you mentioned people can select categories of records when submitting requests, is that tracked by GovQA, and can I look in the portal for that, or is that something you can provide to me, number of requests by category?
I think I can run reports on some of that information. You know, one of our projects that we were looking at before the pandemic was trying to have a dashboard available to the public, but we're having some export technology problems that we're still trying to get resolved. So we don't have a dashboard, but like I said, we want open data. So we want open data on public records request as well. And so that's one of the projects we're working on.
I've been interested in those too, so I may have to circle back with you and pick your brain about those.
I do try to keep those stats for PPB, not official reports from GovQA, but even though I get some of those reports. So I might have some of that information for PPB. I can send that to y'all. So
that would be helpful. Thank you. And Adam, thanks for your patience. Please go ahead.
No worries. Thanks, Jennifer, and thanks, Tammy. This is really helpful, and I really appreciate the time. In preparation for the meeting, I knew that you guys fulfilled a lot of different public records requests, so I wanted to do a little digging into some of the organizational background that might be necessary there. And in looking at the City of Portland budget, it looks like you got about 60 people in the records division at PPB. Is that roughly correct? I saw about 48 public records specialists and about 9 public records training coordinators. Is that?
To be clear,
we are authorized for.
Yeah.
We have 25 record specialists.
And only 9 people assigned to do public records.
Yes.
The rest do general records work. So every record that a police officer writes has to do a whole host of things to be considered complete. There are only 9 employees who are working to fill the 24,000 public records request and the 20,000 interagency request that the PPB receives.
So in some of our slowdown is that the records department is obviously half staff at 25 when we're supposed to be at, I actually think it's 48 and a half is what we're really authorized for. But they need to get those reports completed before we release the report, because we need to make sure that it's done accurately and distribution to other agencies has already been done. To get the reports into our system, records has to do their first step of processing. So since we've been so shorthanded, they basically just do the first step, and then we leave it in the system until we have time to be able to finish the processing of it. Usually in the meantime, a lot of those records are being requested. So through the public records, so I need to find someone on my record side to process it so that they can finish it on the public record side. So it's a little bit of a delay for us. We're trying to work that out a little smoother, although I have some union issues with the job classifications, so it's a little more difficult than you would anticipate it to be.
I really appreciate that. Thanks for the context. It's super helpful to kind of, I think it's important for us to recognize that a bunch of people have to touch these records as they kind of go through the process to maintain that publicly identifiable information. And so really appreciate the time today, and those are all the questions I have.
Any questions about the staffing elsewhere or anything, Adam?
Not really. I
Okay.
looked a little bit at the charge for services, the proposed budget line item for, looks like the PPB is expected to take in about 2.8 million in charge for services in the fiscal year of 2021, but it looks like the records division itself is budgeted for about 13 million. So I just thought that was kind of an interesting data point, but
yeah, that 2.8 charge for services, that is not all records. Again, I'm preparing some more information about that for the 22nd, but you know, PPB takes in some funds for other purposes, and believe me, records is not getting 2.8 million for public records.
So the part of
If they were, we would be hiring more people.
Yeah. A significant amount of our records time is taken up by auto records. So that's where we keep track of all the cars being towed, or our teletype part where we're entering all missing people. So a majority of that's why the records people, since we're half staff, is doing those positions instead of distribution of records. So that's why the public records has had to kind of help take over that. So
Thanks for that. I just want to do a time check. It's 3:04. We started late and we still have 2 other speakers to hear from. So Shasta, I'll ask you just for one more question, please, and then
Okay.
we'll move on to our next speakers.
Okay. Very quickly, I'm confused why there isn't full staffing. Why are there 9 positions filled out of 48?
No, I'm sorry. There are 9 assigned public records positions. They are filled. There are 48 records positions, and 25 of those are filled. Right now, it is an employee market, and Tammy, when she's not on the phone testifying, is actively recruiting and hiring. But people retire and they go work other places, and unfortunately, they get to make those choices. We can't refuse to let them leave, even if they're wonderful, fantastic employees. And so we are hiring more people. The other thing is, you know, when I mentioned, like, I had to get CJIS certified and backgrounded and all of that, even as an attorney, to supervise their work, all of the records people have to have a level 2 background, and it can take 3 to 6 months. And so standing up 25 records people is not a fast process, though Tammy's going as fast as she can.
Okay. Thank you.
Again, thank you both so much. Please feel free to hang around if you want to hear from other speakers and perhaps offer your own input on what you've heard from them. I should have told our 2 other speakers that they should have felt free to chime in at any point during this presentation as well. Given our limited time, let's just go right to our next speaker, Leila Yelisetti from DEQ. Welcome, and we look forward to hearing from you next.
Well, thanks so much for inviting me. And I do not have slides, but I'm going to read some remarks and I can share the written document after this as well. So my name is Leila Yelistetti. I'm the Information Governance Officer at the Oregon Department of Environmental Quality. Thanks for your invitation to hear about DEQ's experience with PII. Before I delve into that issue, I did want to share a brief background about our agency. The DEQ's mission is to be a leader in restoring, maintaining, and enhancing the quality of Oregon's air, land, and water. With over 700 staff located across the state, we operate hundreds of programs, including permitting, licensing, certifications, vehicle inspections, environmental cleanup, environmental monitoring, and much more. And we don't obviously get as many requests as something like City of Portland, but we do actually have the second highest number of records requests of any state agency at around 300 per month. Many of these relate to a specific facility or site that is of interest to specific property owners or developers. And then we have other requests that range much broader in scope, reflecting public and media interest in agency decisions that impact our shared environment. We currently have a full-time records staff of 2, myself and Public Records Coordinator Kristen Mercer, who's also here and can help answer questions. And so in order to manage our volume of requests, we rely on a network of over 50 public records coordinators in different programs and regions around the state. Last year, we also implemented GovQA for tracking our requests, and I'm proud to say that for the past several quarters, we've had a 99% compliance rate with statutory deadlines, completing the vast majority of our requests in just a few days. So compared to other agencies, including the ones we just heard from, DEQ does not collect a large amount of PII, but I will outline some examples of PII we do handle and some of the challenges we face with it and other types of sensitive information. So the one major issue that we see in handling PII is it's a very broad and not well-defined category, and it includes a variety of types of information with differing levels of sensitivity. So we've had to kind of take a variety of approaches depending on both the nature and the format of the PII in question. On the one end of the spectrum are things like personal health information, passwords, social security numbers, information that's clearly highly sensitive, regulated, and exempt from disclosure. In general, DEQ collects these forms of PII sparingly and in highly controlled contexts, like, within our HR or finance departments. And so they're relatively easy to identify and redact in the event of a request. One major exception that we encountered recently was in the course of scanning some legacy records with the goal of making them available online. And as we started going through, it turned out that in years past, some agency employees were in the practice of placing copies of canceled checks in a file as evidence that a permittee paid their fees or fines. And these checks, of course, contain bank account numbers, which may still be active. And we have yet to find an easy way to identify and redact this information without manually reviewing millions of pages of files. And we haven't found most of the commercial redaction tools scan for things like credit card numbers and social security numbers in certain formats, but we haven't found a tool that can help us find those old printed check numbers. So that's still a challenge. So at present, we have those stored internally, and then we just review and redact individual files upon request. Leaving aside this more obviously exempt data, the majority of the PII we handle at DEQ occupies much more of a gray area. Information like name, home address, phone number, even birth date are generally not considered exempt under public records law, since the personal privacy exemption is a conditional one, and we have to balance the extent of the invasion of privacy with the public interest in disclosure. At DEQ, we collect PII of this nature in a variety of contexts, from individuals applying for permits or certifications, electric vehicle rebates, to those submitting pollution complaints or submitting public records requests. And our general approach to these types of information is to only release them on request. So keep them only internally accessible with the understanding that there's a different public reaction to releasing information to one person versus posting everybody's addresses on the internet. But of course, the caveat being anybody who we release that information could turn around and post it to the internet themselves. But that's been our general practice. And this policy also allows us to evaluate whether there's other circumstances dictating that an exemption may apply. So someone's home address may be protected because they have a personal safety exemption or something like that. And one issue, one area where this happens quite frequently is with complaints. So anybody in Oregon can submit a complaint, pollution complaint online. And on our intake form, we have the option for complainants to keep their identities confidential. And this is protected by the confidential submissions exemption under public records law, with the goal of encouraging residents to come forward with information without about possible violations without fear of retaliation. So, people reporting their employers or maybe their neighbors or anybody who might be able to retaliate. And thankfully, we've been able to set up our complaints database such that if somebody marks that they want to be confidential, the report can be produced in a redacted form, which makes it much easier for submitting public records requests. Although listening to the last speaker, it doesn't stop people from disclosing other sensitive information in the narrative section of the form. So that's something that we need to look out for as well. And I think that example underscores the relative ease of identifying PII when it's in a structured data format. Because in contrast, some of our biggest challenges lie with unstructured data, such as documents and emails, not to mention documents attached to emails. In recent years, DEQ has received many very large requests for large numbers of emails, sometimes into the tens of thousands. And we've yet to find a way to automate review for sensitive or confidential information. Keyword searches can be imprecise. For example, it may pull in an email from an employee to their manager that includes an update on a project that's relevant to the request. But in that same email, there's also a request to take time off due to a medical condition. Aside from PII, the other major categories of exempt materials we handle regularly are confidential business information, which is probably one of the biggest challenges for us, attorney-client privileged information, and internal advisory information. And unfortunately, in the past, not all of these had been clearly labeled, and conversely, many emails contain boilerplate confidentiality footers, which do not necessarily mean that the contents are actually exempt. So in the short run, we've implemented a number of measures to reduce the risk of inadvertently disclosing confidential or sensitive information. For members of the public and regulated entities submitting PII, we've developed some standard disclaimer language informing them what information about them may become subject to public disclosure so they can make informed choices about information they want to share. For agency employees, we've created a guidance document with descriptions of common exemptions at DEQ and instructions about appropriate labeling and storage of this information. Although, of course, these don't address the legacy record issues. And we've created an email review procedure, which includes a 3-part process where the records team takes a first pass and then a manager reviews and determines if we need attorney review. In the long run, we hope to streamline and automate many of these processes given the volume of information continues to grow. At present, DEQ is in the midst of a major technology modernization project called Your DEQ Online, which will replace many of our formerly manual and paper-based processes with a central online portal. Not only will this make it possible to make many more public records directly available to the public, but we can also more easily identify fields which may contain PII and ensure that those are appropriately protected. Another opportunity is the state's recent implementation of Microsoft 365 suite, which it's not been turned on yet, but I do understand includes a functionality of applying security labels to emails and other content. So we look forward to, it's an enterprise-wide system, so we're looking forward to working with Department of Administrative Services on implementing those in the future. And that's the end of my planned out remarks, but I'm more than happy to answer any questions.
Thank you so much, Leela. I know DEQ has been doing so much. I really appreciate you sort of piecing that out for us, because it's a lot of information and it's, you know, your agency is quite broad. And I did just have one question related to that. With over 700 staff across the state, and you said 50 public records coordinators as well, and with you providing these guidance documents, I'm just curious what level of sort of like training or reminding is going on for these employees. Like, you know, because whenever anyone starts a job, right, you receive a whole load of information. We're lucky how much, you know, if we retain any of that. But I'm just curious, what is the process DEQ implements to like sort of get that information in front of the employee and or provide reminders to them about it, at least for those that actually handle this type of information?
Yeah, great question. Just to clarify with our coordinators, they are mainly admin staff who have other duties. So they're not full-time dedicated to PRRs. But we do monthly meetings with all of our coordinators where we provide updates and give opportunities to ask questions. But really a lot of the training around confidential, sensitive information has to go out to everyone, because any number of employees across the agency may handle this kind of information. We have annual records training that's required of all employees. That's an e-learning. And then beyond that, we try to have an open door and always are offering to attend different department meetings, meet with staff, provide more guidance. I think we're going to try to do a little bit more around regular PSAs in our agency newsletters around records related topics. So we had one recently because, yeah, you tell people things one time and then they forget. So we're trying to reinforce, you know, we've implemented MS Teams. Those Teams messages are also public records. So kind of reminding people to keep their chats professional and things like that. So we try to get it out there as much as we can.
Great, thank you. Adam, please go ahead.
Thank you, Leela, for the time today. Really appreciate it. I'm just not so much a question as a forewarning apology. I'll either myself or our comms director, Andrew Chiapello, will probably be reaching out to you at some point in the coming weeks to talk a little bit about GovQA, kind of how has it worked for DEQ. And we are similarly resource constrained over at DAS about our public records requests and just any lessons learned you may have. So appreciate the time. And again, apologies for bugging you in the future.
Not at all. Happy to share.
Shasta.
Hi, thank you. Yeah, I was curious about two things. So you mentioned that there's confidential submissions thing. Can you talk a little bit more about what that is? Is that a DEQ specific law or what is that?
No, it's one of the 500 odd exemptions under public records law. It's written broadly, so it doesn't just pertain to complaints. But there's a 5-part test. So it has to be information that was voluntarily submitted to the agency, was submitted on the condition that they remained confidential, and the agency obliged in good faith to keep it confidential. So it's really, the idea is to encourage people to come forward to provide information that they otherwise may not be comfortable providing. And it's been challenged. I think just last year it went to the Attorney General's, one of our requests around this, and it was upheld by the AG on that basis. So we feel pretty confident.
Okay. Yeah, I don't know if our PPB people are still here, but I'm curious why that wouldn't apply to the concerns about the victims in police investigations.
Well, I would like to just chime in on that a little bit too. So Jennifer Johnson pointed out that we're referring to RRS section 192.3554. And one thing that has been held when adjudicating disputes over disclosure of this information is whether or not the person who submitted the information did asked for confidentiality at the time the information was submitted, because that impacts whether or not that exemption can be utilized by a public body, as well as the other multiple steps that are needed to be analyzed before determining if in fact this information can be disclosed. But the courts have generally not been friendly, I would say, to withholding this information if it was not requested at the time that it was submitted. So I think actually DEQ has done a very good thing of asking at the outset, you know, are you asking for any of this information to be confidential? That in and of itself will not prevent that information from being released. That's merely one of the elements that has to be satisfied. But yes, if you'd like to add any thoughts, or Tammy from PPB's perspective, please feel free to.
I believe that sex abuse victims are asked if they want to submit their information in confidence, but
Yes.
I don't believe that we can ask every single person talking to the police if they want to submit their information in confidence. Additionally, the courts are, the public records law is supposed to be read to disclose records. And so they have indicated that information in police reports is generally disclosable. And my concern would be that if we attempted to exempt a broad swath of police records, the court would not view that favorably. So, I do think we could meet the 5 standards for sex abuse victims, because their situation is distinct and more personal. And so this is the type of information that is very private that people would want to keep private. But the courts have generally said that someone's home address in general is not the kind of information that is intended to be kept private. So if dates of birth and home addresses are the kind of things that the state of Oregon decides should be private, that would need to be a legislative fix. It is not the sort of thing that the city of Portland at this time thinks that it could just do with the current legal background that we have. Shasta, does that answer?
We might have lost Shasta's audio for the moment.
Okay.
Shasta, please follow up in the chat if you're not able to answer right now. I don't have any other questions for
Hey,
Leela.
sorry,
Oh, there
I
you
got
go.
most of that, but my son needed help with something. So yes. I don't think about asking every single person, but maybe like in those instances when people are afraid of coming forward as a victim, that might be helpful. So
And we do that with sex abuse victims. Again, as Todd pointed out, we have to do it at the time they make their reports.
mhm.
And the problem with that submission, right, is we can't really give them a guarantee. We think it meets the 5 criteria. We will defend it, but ultimately a DA and a court are going to make that decision. And we have lost some recently where we thought it was either confidential or private. Somebody said they wanted to be anonymous. Somebody else said they feared retaliation, and the court ordered us to release it. So of course we had to release.
Okay. I had another question for the DEQ person. I'm not sure what, if I'm still in line.
You're here. You're here.
Okay.
Leela's here too.
Okay. Leela, you mentioned that there's a email review procedure where the records team takes a first pass and then a manager gets to decide if there's a legal review. Is there an independent review process if the request is about the manager's own emails?
There is not. So the managers are only tasked with identifying items that are potentially exempt from disclosure. So it's not a review for relevance. It's, you know, we ask that they just identify, because we have kind of the records team who's most familiar with the different provisions of the public records law and the exemptions themselves, but then the managers are much more familiar with the subject matter. So certain types of reports, you know, certain acronyms that we don't know, but they're like, oh yeah, these types of, you know, reports are always contain confidential business information or things like that. So we kind of do need that second set of eyes with the subject matter expertise. So I will say, for the most part, managers are reviewing, you know, emails that are pertinent to their department. When it's a topical records request from media or from a law firm, if there was a request for emails that had to do with any sort of HR matter, or ask, you know, if it was a manager asking for an employee's emails or vice versa, then we have a separate process that we go through with HR, and then it would be HR that reviews those messages.
And is that kind of potentially 3-part review process, is that calculated in any fees that you charge the public?
Yes, it would be. We typically, so our email requests are the ones that typically get much more voluminous and entail fees. We work with requesters as much as possible to narrow the request, to reduce the amount of fees that might be associated. Unfortunately, a lot of those larger requests are from law firms, and they don't usually care that much about the fees, because they're just going to be expensing those to their clients. And then, you know, with media, we almost always grant full fee waivers. And in general, we've been pretty successful working with media to narrow the scope as much as we can, so that we're not having to charge them any fees. But yeah, if we're looking through 10,000 emails, then it's gonna take some time, and we're probably gonna have some fees.
Jennifer, if you could provide us the elevator pitch version of what you'd wanted to say, because then I'd like to move on to our next speaker, please.
Well, along the lines of what Shasta is asking, we use a similar, I don't think it's 3-part, but it's 2-part. And the point of it is to limit the attorney review to make things cheaper for the requester. So you have a low-level, cheapest employee do an initial review and then flag things that seem questionable. And with DEQ, it seems like a manager who's paid maybe more than your record person, but less than an attorney, decides if they can resolve it and then go to an attorney. We do something similar, so that we try and have the lowest paid person resolve as much as possible. And then it only goes to an attorney for legal questions that an attorney has to resolve, again, to try and keep it as cheap as possible for the requester.
Yeah, we have a similar approach. And I'm happy to provide a copy of our email review procedure. We may be revising it, but if that's helpful for the committee.
I think it would be, yes. Please send it our way. Thank you. And thank you again, Leela. We really appreciate hearing about what DEQ is doing. I think it's going to be very helpful to our efforts. Next up, we have Raghav Shanmugasundaram from OHSU. Welcome, and please tell us about what's going on in your world.
Appreciate it, Todd, and feel free to shorten my last name to SHAN, Shan. That makes it easier for everyone, including myself. I am legal counsel for OHSU, Raghav Shan, and thinking about where PII or PI-related material exists in the institution, I think it exists in three distinct areas. That's the employment context. We have over 19,000 employees. The education context, we have approximately 4,000 students. And in the provision of healthcare, I don't have a number for you, but we have a lot of protected health information in the institution. I think it makes sense to kind of break out each of these three areas, because while there are some commonalities in the maintenance and protection of this kind of information, or each of these kinds of information, there are differences in how we collect them, obviously, and most definitely in what, if anything, is disclosed specifically in the public records context. So I will start with the healthcare information. Obviously, the collection of that kind of information, individually identifiable health information, what's called protected health information, is through the process of rendering healthcare services, right? Someone comes into the ED, they're triaged, they receive healthcare services, and through that process, they're providing information about themselves. We're also creating protected health information through their diagnoses and treatment. The same for the non-urgent side, right? Clinics, primary care physicians, there's a scheduling process, there's a registration process, and the provision of healthcare. And so in terms of maintenance and protection, OHSU has a specific department within our IT department. We have an Office of Information, Privacy, and Security, and they are a department that manages and oversees the maintenance and protection of PHI. So they promulgated several policies that are applicable to everyone in the institution that handles PHI. Those policies include things like encryption requirements for where feasible for OHSU equipment that uses or stores such data. Policies include detailed matrices on how to safeguard information depending on the type of information, system logging. This office has the ability to review logs, to review access of who's actually accessing such information to ensure that there isn't any kind of any breach. They also perform security reviews. So when OHSU intends to introduce new technology in our environments, the first step would be this office and their IT and the IT department conducting a security review, which basically is to ensure that any new technologies complies with not only the information privacy and security policies, but state and federal regulations such as HIPAA for PHI and FERPA for student records, which I'll also discuss a little bit later on here. From the when we're still talking about maintenance and protection from the individual employee standpoint, access to systems that involve PHI are provided as needed, meaning if it's an essential job function of an individual to access and use PHI, assuming that they have completed the appropriate training, then they would be given that access. And at OHSU, we have annual trainings regarding the information privacy security policies, and that's regardless of whether an individual is in a patient-facing role or they actually handle PHI on a daily basis. That kind of training is for every employee, and it covers things, educates on items such as what is PHI, what to do if you encounter PHI, what to do if you believe someone is mishandling PHI. And then, of course, our healthcare professionals, they have their own even more frequent and differing trainings throughout each fiscal year that they undergo. The last thing I'll say in terms of maintenance and protection of healthcare information is under HIPAA, and well, by necessity, OHSU contracts with third-party vendors to assist in the administration of healthcare services. So for instance, billing services or contracts to with third parties for scheduling or registration software. What HIPAA requires is when OHSU or any covered entity enters into that kind of agreement, they also enter into what's called a business associate agreement. And that's an agreement where the third party is providing assurances to the covered entity that they understand the covered entity is subject to HIPAA. They understand that because of their relationship and their use of PHI, they too would then be subject to HIPAA obligations, and also enumerating that the use of PHI, however the contractual relationship is limited to exactly what the contract calls for, and there's no further use of that information. In terms of disclosure, in the public records context, if protected health information is found in responsive records to a request, OHSU would exert ORS 192355 subsection 8, which is a unconditional exemption for federal laws that prohibit disclosure of confidential information. So we would exert HIPAA through operation of that exemption. Otherwise, it's thinking of disclosure in other settings, unless a patient has authorized disclosure or there is disclosures permitted or necessary by law, there would not be any other disclosure of protected health information. So moving to the education context, as I mentioned, OHSU has approximately 4,000 students. We have 5 schools: the School of Medicine, the School of Nursing, School of Pharmacy, School of Dentistry, and the School of Public Health. Collection of PII in that setting generally occurs during the application and acceptance process to a respective program or school. And in this scenario, the maintenance of this information is done through our registrar's office. So student records, which include PII, are kept at the registrar's office. The access to PII is limited to an as-needed basis. So if an individual in the institution has a legitimate educational interest to carry out a job function, then they would be granted access to the PII. The same policies that I described in the healthcare scenario, which is the policies that are enumerated through our Office of Information, Privacy, and Security, are also applicable to PII in the FERPA context. In addition to those policies, OHSU does have an institutional education records policy, and that policy explicitly describes what education records are, what they're not, under what circumstances PII in the educational context can be disclosed without student authorization, and students' rights to restrict disclosure of directory information. And I'll speak briefly on directory information because I think it is pertinent to public records. FERPA, which is the act that is intended to maintain student privacy, does allow for disclosure without student consent of what's termed directory information. And directory information at OHSU is limited to the full name of a student, their major or field of study, dates of attendance, their enrollment status, and any degrees or certificates that they received during their tenure at OHSU. And so the FERPA Act finds that directory information does not constitute an unreasonable invasion of privacy, and that kind of information that's enumerated by the institution of what is directory information can be disclosed without student consent. However, students can restrict disclosure of directory information, and that is reflected in our policy. That's done through, our registrar's office annually, they send out a form to students that allows them to restrict disclosure of directory information. So if they fill that out and they provide it to the registrar, in the scenario where we receive a public records request for directory information, which we do, we regularly receive public records requests from branches of the military for directory information, which I understand they use for recruiting purposes. What would happen is our public records coordinator would provide that request to the registrar's office. The registrar would check to see if any student has a restriction of disclosure on file, and then process that accordingly. And then outside of that scenario, the directory information scenario, any external disclosure would occur only if a student authorizes disclosure, or if OHSU, if there is a required disclosure under law and OHSU policy. The last kind of area is the employment context. As I mentioned, OHSU has over 19,000 employees. The collection of PII typically comes through the application process. Additional PII may be collected in background checks if it's a role that requires a background check, and then also after acceptance of after an offer is extended, and if an employee accepts that offer, in the administration of benefits, not only will we get PII of the employee themselves, but also if they have family members, eligible family members they want to include in benefits, then we will be collecting that information as well. The maintenance and protection of that information in the employment context is maintained through specific HR systems. Access is granted on an as-needed basis. Briefly, to gain access to such systems, an employee who is seeking access to PII would first create an internal ticket in the system, and then there's a two-level process where that person's supervisor would have to approve the individual for access of the PII, and then the data steward, or who is the director of HR information systems, would also have to approve that use. And the need for continuing access is reviewed and assessed periodically. So it's not uncommon for individuals within the institution to move within different departments and different roles. Our data steward, the director of human resources and information systems, they would oftentimes, every so often, they would look to see who has access to such material. And if it looks like, well, this person is a clinical nurse, is there a reason for them to have access to employee PII, then that would be a conversation that would be had with that individual and their supervisor to determine whether or not continuing access is needed for that kind of information. And if not, it would be that access would be terminated at that point. So the last thing I'd say about maintenance and protection of employee information is it's similar to in the healthcare setting. So for benefits administration, we also contract with third-party vendors. We enter into business associate agreements with them as well to ensure that the protection of PII that is that they may come into contact with. In terms of disclosure, in the public records context, to the extent that PII is found in response to public records requests, or public records responsive to a request, we would evaluate whether either the personal privacy exemption or the public employee personal information exemption would be applicable. And if so, we would apply as appropriate. And oftentimes, especially with the former, the personal privacy exemption would take some communication with the affected individual, the affected employee, to determine whether or not there is material that needs to be, that needs to be redacted outside of Social Security numbers. And we would process accordingly. So I'm happy to take any questions to the extent I'm able to answer them.
Hi.
Hi.
So question not like exactly related to what you were just talking about, but I bet you're a great person to ask this question to. Let's just say we have a hypothetical situation where somebody is upset about something that OHSU did as a patient. How do people waive their own HIPAA rights so that OHSU can respond to their concerns?
So we have a patient relations office that handles those kinds of those kinds of instances, a patient would first contact, well, a complaint will be routed to them, to that office, and it would be handled in that scenario through interaction with that office to determine what is the, I guess, without knowing what the exact issue is, it's a little difficult to.
I guess I'm approaching it as a media person. So if somebody comes to the media and says, I want to talk about this, I've often had the occurrence where I go to the agency and the agency says, oh, we can't talk about that. And it's like, well, this person whose privacy it is that you're concerned about violating is talking to me about it. So how does the agency then talk to me about it? Or how does that person then waive their own privacy?
So I think if I'm understanding it correctly, is a patient is talking to the media, and then the media is coming to the covered entity or the hospital, wherever the person has been seen, and they're saying we can't provide that information, even though that other person, the individual affected, is talking about it. The reason that we cannot talk about that or we can't provide the information is without an authorization, a valid authorization to speak about that patient, we can't do so. So the patient is free to talk extensively about whatever it is the issue is or whatever they want to speak about in terms of their own medical history. But as a covered entity, we have to comply with HIPAA, and we cannot. There's an HIPAA exception that allows us to talk to the media in that form or fashion.
Okay, so you just said it without an authorization. So I'm asking, what is the authorization? What is the appropriate? Is there a process that somebody can use?
There is, yep. So our health information, we have a health information department where an individual can detail what kind of records they'd like for OHSU to release or talk about who to release that information to. And then if we receive that, that's when we would be able to release records or, right. Yeah.
So it's just a standard like release of information ROI form, or?
Well, it is an authorization form, but it does certain components of it have to comply with the HIPAA regulations. So it would be, we do have a standard form that we use, definitely, but it's HIPAA compliant as opposed to some other sort of authorization.
Okay.
Hi, everyone. I just wanted to say I was having some serious Wi-Fi issues and actually went off camera hoping I could stay in and eventually got kicked out. Raghav, I apologize for missing part of your testimony, but thank you very much. And Shasta, thank you so much for jumping in, asking a question. I have a couple of my own when you're ready for some more questions. Okay. And I'm sorry if this is something that's already been asked and answered, or if you testified to this and I missed it, but I'm just curious about a couple things. First of all, do you know your how many requests you get a year and sort of how they break up amongst these three categories?
In terms of requests, we are nowhere close to PPB or DEQ. I would say, unfortunately, I don't have those numbers with me, but I would be surprised if we get more than 250 requests a year. In terms of how it breaks up, we very rarely get requests that involve patient health information, public records requests that involve patient health information. Oftentimes what we see is individuals are seeking their own medical records, but they misroute themselves to public records instead of the health information department where they can get that information. In the education context, I think maybe you missed that part, but we regularly receive public records requests for directory information from various branches of the military throughout the year. So I would say we would get about eight of those a year. And the employment context, when there are the kind of requests that I'm thinking about are requests for leave time. We get those often. But again, I don't know that we very often get personnel records requests. That we do get those occasionally, but it isn't something that I would say is a majority or a substantial portion of the requests we receive.
Thank you. And It seems like your system is very heavily technology based, and whether or not it is, what abilities does it have to identify what OHSU considers PII or personal health information, and also to then redact that information either at the time of submission or to provide a redacted copy, sort of an automated or technologically based way?
So are we talking specifically about the administration of public records?
Well, I suppose it depends on the extent of your system's ability to sort of separate those out. But at any point when information is added into the system, is it sort of automatically flagged as confidential? And does that assist then in the public records request context of providing records that are responsive and can be disclosed?
So there isn't, my understanding of the IT systems is that there is not a way where all the systems are connected, and that's driven primarily by the security concerns in the healthcare side, as well as, primarily the healthcare side. So there isn't an ability to redact automatically from the initial creation of a document or receipt of information. We recently, at the start of this year, have started using Next Request, which is a public records administration tool. And that's made, we have one public records coordinator at OHSU, and that's the mechanism that we use to apply redactions when appropriate and when necessary.
Well, then, without asking for you to get too technical, can you tell me a little bit about using or that system? Because I'm not familiar with it. I would just love to know a little more.
So I think the right person to ask is our public records coordinator, but my understanding of the way it works is, well, you could go onto OHSU's public records portion of our outward-facing site, and you'd be directed to OHSU's Next Request software. The way it works is an individual can, it's all electronic, obviously. The individual would describe the records that they are looking for, and then internally on our side, our public records coordinator can designate, okay, this looks like it's a research request, and she can send it there, and then they can determine, is a prepayment fee appropriate? Is it going to take, X amount of hours, etc. They would communicate back to her within that system, and she can create a prepayment estimate in that system and kind of just do everything there. Previously, what it used to be like is just a lot of emails between her and different departments and manual redactions. So just makes administering public records a little more efficient.
Great, thank you. Any other questions? Excellent, and we're even pretty much on time. Well, Raghav, thank you so much. OHSU is definitely an institution that I feel like I didn't know a lot about, especially when it came to its public record systems. This has been very illuminating, so thank you for taking the time to speak with us today.
Thank you.
Well, great. And again, for our speakers who had some written testimony to provide, I did notice when my computer was working, some emails came in, so I think we probably got most of what we asked for, but please follow up in due course with any remaining information we asked for you to provide or that you would like to provide that you think would be helpful to add to the record. I do want to use our remaining time to hear from any members of the public, and that includes our fellow public employees who are in the meeting, if they would like to be heard on the issue of public bodies collecting, receiving, safeguarding, and providing what we are calling personally identifiable information. And if you're able to, please either raise your hand electronically, or if you've called in, just go ahead and speak up and you can be recognized. Well, hearing none at this time, I will say to our subcommittee members, since we don't have a quorum, we will have to follow up. I will follow up with all of you offline in a way that does not violate the public meetings law to plan additional meetings and testimony. But otherwise, everybody, thank you so much for your time. Again, this is very helpful to our work. I hope you all have a very good day. Do I have a motion from a committee member to adjourn?
I can do that. Motion to adjourn.
Second,
I think that falls to me. I second it.
does
Thanks,
indeed.
Adam.
Thank you so much. Thank you, everybody. It's been very
Thank you,
helpful today.
everybody.